Okay, I guess that's our signal. So, welcome everybody. My name is Brian Lepard. I'm a professor of law at the University of Nebraska, and I'm also chair of the ABILA Committee on the Formation of Rules of Customary International Law. That's a real mouthful. So we just call it the Customary International Law Committee. So we're pleased to be sponsoring this panel. And of course, our panel today is extremely relevant to the theme of our overall conference, Powerless Law or Law for the Powerless, because we are in fact focusing on the rights of children. And as you have heard, of course, this is the 100th anniversary of the 1924 Geneva Declaration on the Rights of the Child, which really, in many ways, is one of our first universal human rights declarations. Set the stage for many other efforts to protect children's rights. And our focus today will be on children's rights to be free of labor and exploitation. And we will be focusing particularly on the role of customary international law in protecting these rights. So, of course, in order to do that, we need to investigate the role of the many treaties that have been adopted to protect children from child labor and exploitation, including, of course, the Convention on the Rights of the Child, as well as many ILO conventions, but two in particular that we will be hearing about. And we have a very distinguished panel, but before I introduce all of them, I did want to give special thanks to Alan, whoops, there he is, Alan Franklin on my right here, who is a member of the committee and really took the lead in proposing this topic and putting together this panel. So I really want to thank Alan for all of his hard work on this. And I'll also just make a few other announcements before I introduce each of the other panelists as well. So first of all, CLE credit is available for this program. So please sign up if you're interested in that. And we did circulate 3 documents for that purpose. So one is the statute of the International Court of Justice, which does mention customary international law as one of the primary sources of international law. A second is the conclusions on the identification of customary international law, which were originally drafted by the International Law Commission and then formally endorsed by the UN General Assembly in 2018. And of course, those conclusions are very relevant to our discussion about what norms on child's rights may now be part of customary law, including the role of treaties, as well as UN General Assembly resolutions informing customary international law. And then the third is an article by Alan on what to do when you discover child labor issues in your supply chain. So I realize that our time is brief, so I just thought I would set the stage, though, for the discussion among our panelists by, of course, just briefly reviewing some of the key documents in this area that may have generated customary international law. So the first, of course, is the 1924 Declaration on the Rights of the Child, which is very brief, but generally provides that children have a right to be free of exploitation. And then, of course, we had 35 years later, the UN Declaration on the Rights of the Child. And Rosanna in particular is going to be talking about the legal significance of that declaration and its provisions on child labor and exploitation. Then, of course, 30 years later, we had the 1989 Convention on the Rights of the Child. In fact, some of you may have been to the panel on that convention that just preceded ours. The ILO has, from its inception, been very active in protecting children from child labor. And so 2 key conventions of the ILO are the 1973 Minimum Age Convention, as we call it, number 138, which, as the shorthand name suggests, sets a minimum age for child labor with various modifications, shall we say, and some flexibility clauses depending on the state of development of the country concerned, and it has options then to select some lower ages than those prescribed in the convention, and differential rules, in part depending on the type of work involved. And then we have the 1999 ILO Convention number 182 on the worst forms of child labor. Both of these conventions, by the way, have been widely ratified. If I'm not mistaken, currently the Minimum Age Convention has 176 parties, and the Worst Forms of Child Labor Convention 187, which is all member states of the ILO. And then ILO also in 1998 adopted a declaration on fundamental principles and rights at work, which effectively designates these two conventions I mentioned have been designated as, in fact, fundamental conventions that are actually binding on all ILO member states. So we really have this vast network now of treaties that have been very widely ratified. Of course, you know, the Convention on the Rights of the Child has been ratified, I believe, by 196 countries, excepting this country. It's one of the really the only holdout. So we have a series of widely ratified treaties raising questions about is can this be evidence of the customary law norms on child labor and exploitation. Then in 2011, the UN adopted guiding principles on business and human rights. And that raises important questions about what obligations do businesses have under customary international law or other sources to protect children from child labor and exploitation. And then just finally, I'll mention that the Sustainable Development Goals adopted by the UN in 2015 in Target 8.7 aim to eliminate all child labor by next year. So that might be a challenge, but that is, wow, I'm sure at the time they were adopted, 10 years, that sounded like it was a long way away, could be achieved, but here we are. And I think as we're about to hear, especially from our esteemed expert from the ILO, Ben Smith, we are far from achieving that goal. So what we would like to look at, as you know, are some key questions, including, why is child labor and exploitation on the rise, and what's the role of international law generally in trying to stem that rise? And then further, what norms in these treaties and declarations I mentioned might now be customary law? And does that matter? Does it matter if they're customary law, especially when we have such widely ratified treaties? And then, of course, we may have a chance, we'll see, to look at the legal status of these guiding principles on business and human rights. We're very fortunate. Some of our panelists have had a lot of experience working on this question of the role of businesses in protecting children. And then finally, what can we do now to make this a reality? Can we really eliminate child labor? How can we do that? That'll be our final question. So as I said, we have very distinguished panelists. I'd like to take just a minute or two to introduce them. So on my far left is Owen Brown, and we are so delighted that we have someone who is not a lawyer, right, who can bring the perspective of a sociologist to this problem. And in fact, he is very distinguished. He's a professor of sociology at Medgar Evers College, where he's also been chair of the Department of Sociology. And he has, I should say, he's currently working on a book entitled The Awakening: Women of African Ancestry Who Lived Free, or Enslaved, and the Making of America. And then just to my left, we have Douglas Castle, who is counsel on business and human rights and public international law in the law firm of King & Spalding. He is also co-chair of the Business and Human Rights Lawyers Association. And prior to joining King & Spalding in 2018, he taught, published, and practiced in the field of international human rights as a full-time academic, among others at Notre Dame Law School. We're also pleased to have Rosanna Duplano, who has come all the way from the UK, and I must say, it's such a victory that she's here, because she has tried to come to this conference for 3 years in a row. And I guess the powers that be had other plans for her, but she finally made it. So we are just absolutely delighted that she can be here and bring her expertise on the legal significance of UN General Assembly resolutions. So that is a subject of an acclaimed book that she has written, published by Cambridge University Press. And how the subtitle is How States Use the UN General Assembly to Create International Obligations. So we're delighted to have her here at last. And then, of course, as I mentioned, Alan, just to my right, he has a JD and LLM. He's practiced law for many years. He's taught business risk management for the executive LLM program at Athabasca University in Canada. And he's taught international business for the Royal University of Law and Economics in Cambodia for 5 years. And he's given numerous seminars on child labor issues around the world, including Vancouver, New York, and Cambodia. And then we have Naomi. By the way, I'm going by alphabetical order here, last name. So all of our panelists are equally distinguished, I should say. So Naomi Rothenberg is an attorney at the King County Department of Public Defense, where she advocates for individuals and families affected by criminal, legal, and family regulation systems. And I should say she's particularly an expert in migrant justice, but she did work for the University of Colorado's Camp Center for the Prevention and Treatment of Child Abuse and Neglect. And so she's been able to research and engage in advocacy initiatives relating to the rights of children and families in the U.S. and internationally. So we're delighted that she can bring her expertise. And she is a lawyer. She holds a JD from Seattle University. And finally, let me say how delighted we are to have Benjamin Smith. Thank you for joining us all the way from Geneva, Switzerland. So Ben is a senior child labor specialist of the International Labor Organization in Geneva. He has worked with government, business, trade unions, and civil society to eliminate child labor for 25 years. So he began his career at ILO working in Costa Rica, and he's worked in El Salvador, and back at UN headquarters in Geneva. He coordinates the Secretariat of Alliance 8.7, which is a global multi-stakeholder initiative to tackle forced labor, modern slavery, human trafficking, and child labor. And he also supports implementation of the ILO's program to eradicate child and forced labor called IPEC Plus. So without further ado, again, we are so grateful for our panelists. I would like to say that we are going to do our best to make this a real conversation, okay, among our panelists. So they are going to be sharing their perspectives on the questions I mentioned, but we're going to have a real conversation, okay? And that will also include all of you. So if you can be a little patient, we're going to try to leave about 15 minutes for discussion with all of you. Okay, we're going to make this a real conversation. So that does mean, though, I'm going to invite the panelists to just try to be a little succinct as much as possible. So actually, let's start with that first issue. Like, why is child labor on the rise? What is the extent of child labor? And also other forms of exploitation of children in the world today. And we thought Ben would be in an excellent position to share expertise from the ILO on this. So thank you, Ben.
Yeah, thank you so much, Brian. And it's a real pleasure to be with you this afternoon. So ILO is the UN agency for the world of work. We're unique in the UN world in that we're tripartite. So workers, employers, as well as governments have a role in our governance. And so just to frame the issue, how big of a problem are we talking about? There are 160 million children in child labor, and that number increased by from 2016 to 2020, the first increase that has been registered since we started measuring in 2000. So that's 63 million girls and 97 million boys, almost 1 in 10 children globally in child labor. And in sub-Saharan Africa, it's 1 in 4. So about half of those children, 79 million, are in what's called hazardous work. So this is work that jeopardizes health, safety, or moral development of children. 1/3 are out of school completely, and those that are still in school are more likely to repeat classes and to drop out prematurely. So in terms of sectors, 70% is in agriculture, 20% in services, and 10% is in industry. Most, about 2/3, is in as contributing family member. So there's those families relying on the work of their children to help them meet their basic needs. So in terms of the definition, first, I think it's important to say what is not child labor. So it's not household chores, helping out in a family business, or earning pocket money after school or on school holidays. I think everyone can recognize that this can be actually an important part of a child's upbringing and help them contribute to their household. So what it is, and what we are talking about, is work that deprives children of their childhood, their potential and their dignity, and that is harmful to their physical and mental development. So just a word on how ILO approaches the issue, how we work on child labor, if I may, Brian. First, There are two ways. The first is by setting standards. So the international labor standards that you referenced, these are adopted through tripartite discussions amongst workers and employers, representatives, and governments. The first is Convention 138 that you've mentioned on minimum age, and that stipulates that the minimum age should not be less than the compulsory school leaving age, and in any case shouldn't be less than 15 years. However, you mentioned flexibility clauses, Brian. Indeed, this is an important one. Developing countries basically have the option to set it at 14 as a transitional measure. Another flexible element of the convention is, and really I think because it's so adaptable to country circumstances, I think that's one of the reasons why it's so widely ratified, that countries are able to sort of adjust it. So one of those also is light work, and children as young as 12 years old are permitted to do light work. 18 is the minimum age set for hazardous work that I mentioned. The second convention is the Convention on Worst Forms of Child Labor, and that calls for immediate and effective action to tackle these as a matter of urgency. And so what are the worst forms of child labor? Slavery and similar practices, including forced recruitment of children into armed conflict, child prostitution and pornography, the use of children in illicit activities like drug trafficking, and then hazardous work that I mentioned. And as you said, Brian, this has been universally ratified. So it's the first ILO convention to reach that universal ratification. So it is one of the fundamental principles and rights at work, along with forced labor, freedom of association and collective bargaining, non-discrimination, and safe and healthy workplaces. And you mentioned it, Brian, regardless of whether ILO member states have ratified the child labor and these other conventions or not, they have a duty, because they're ILO members, to respect, promote, and realize those rights. So ILO monitors the implementation of these conventions. Workers, employers, other governments can bring governments to account if they find that the implementation is lacking. So it's sort of an accountability system that's well established and can move countries along toward better application just by public scrutiny and the desire of governments to really avoid being called in front of the ILO supervisory bodies. Okay, so the second one, and I don't want to take too much time, but a big element of our effort on child labor is through technical assistance. So the ILO has worked in more than 100 countries, helping our member states to address the issue. Policy development is critical, but also we work in communities on prevention and remediation of child labor. So strengthening education systems, social protection, which has proved a very powerful tool on child labor, promoting income generating alternatives and decent work for parents so that they can earn enough money to be able to send their children to school and keep them out of work. So it very much directed towards tackling the root causes of child labor. So pervasive poverty, a big reason why it's still with us in such large numbers, weak education system, enforcement, and lack of social protection, lack of respect for other fundamental rights like freedom of association and collective bargaining that can provide, and those are often referred to as enabling rights that can provide good protection against child labor. So all these efforts, and I don't want to paint too gloomy of a picture. We have reduced child labor by 86 million. I mean, not ILO, but the ILO member states with our assistance. So since 2000, even counting that increase that I mentioned. So the overall picture and the trends are going in the right way, but much more is needed to be done, and we certainly need to accelerate the pace. I think 2025, you mentioned it, out of reach. But that's no reason to let up our efforts by any means. So thanks.
Thank you very much, Ben. And Let's turn now to Owen, because you've studied this problem too as a sociologist, right? So what are your perspectives on why child labor and exploitation are on the rise?
Absolutely. Can everyone hear me? Yeah. I think we can all agree that the exploitation, the financial exploitation of children is egregious and it should stop. How? That becomes a little bit more complicated. And I say this, I will utilize a personal example. I remember when I was either 7 or 8 years old, my mother put me in front of the sink on a stepping stool and announced to me that my new job is to wash the dishes after each family meal, right? Did it stop me from going to school at PS 209? That's not located too far from here? No. And did it contribute to our family income? I don't think it would. And I doubt it did, because my father would probably say, no, it did not. Did I feel forced? Yeah. But was it consistent with my labor being exploited? I don't think it was. Because it did not interfere with my education, nor did it interfere with my ability to play with my friends, right? So, having said that, I think we need to think about what are some of the key indicators of the exploitation of children as laborers. I think when we look at children who are forced to work in conditions that are potentially harmful and interferes with their educational and emotional development, I think that qualifies. Right? And I think we all would agree that that qualifies. Now, the International Labor Organization defines child labor as work that deprives children of their childhood, their potential, and their dignity, and that is harmful to their physical and mental development. And here in the United States, we have laws that protect children from being exploited, right? And the federal child labor provision of the Fair Labor Standards Act of 1938 were enacted to ensure that when young people work, the work is safe, it does not jeopardize their health, their well-being, or educational opportunities. Generally speaking, the Fair Labor Standards Act set the minimum age for employment at 14 for non-agricultural workers. It restricts the number of hours young people under the age of 16 may work, and prohibit youth under the age of 18 from being employed in hazardous occupation. But we know that despite these laws, we know that a lot of children are still being exploited. And recently, looking at some research and investigation by the Department of Labor, they found that over the past 5 years, there's been a 70% increase in young people who are working illegally, right? And mostly, we find that the individuals or groups that's being impacted the most by the violation of these child labor laws are minorities and undocumented immigrant children who are disproportionately impacted by this violation. Many of these children come to the US unaccompanied by adults. They're fleeing violence and economic poverty, right? And they often end up being recruited into exploitative labor arrangements. And the sad reality is that despite the fact that we have these laws do not protect these young people, right? And they're the ones that need the protection, but because of their economic circumstances, they're not afforded the same protection as someone who has access to financial resources. So these are the realities of the ground. And I think when we talk about laws are meant to be a leveler, but the reality when you go on the ground is you find that not everyone have equal protection when it comes to the law. And we see this in child labor, right? That's
Yeah, thank you. And Alan, you've had experience in Cambodia, right, on child labor issues. What is your sense of what child labor and exploitation are on the rise?
Thanks, Brian. Yeah, the reason how we came to this whole issue of child labor is that my wife Carol and I, we've lived in Cambodia and taught for about 5 years. And what we saw there was devastating.
A little closer.
It was devastating because you see the children everywhere and they're, the beggars, the kids who are engaged in prostitution, the kids who have been sold to the brick factories. And we came to realize that contrary to sort of the popular belief, the number one, the kids don't go to school there because there are no schools for poor children. That's something that when we talk in the West, we don't quite grasp that and the reason there's no schools for the children, for the poor children, is often that the government doesn't want an educated poor class because they will revolt. So the kids can't go to school, right? And we see that, the kids who are working with, we always talk about the garment factories, for example, the poor children in the garment factories. Well, actually, they're the ones who just won the lottery. Why? They make $200 a month, which is a good salary there. And so they can contribute to their family. If they don't work in the factory, they go to school, if there is a school to go to, they will graduate and they will be able to earn $150 a month. In other words, by staying in school till grade 12, their potential earnings are less than what they could earn at the age of 10 in a factory. So when we started to see these realities and looked at the laws on this, governments are bound by the ILO conventions, by all of the other human rights conventions, but unfortunately, there's very, very little compliance. And without the governments involved, opening schools, trying to deal with child labor, the child labor, unfortunately, is flourishing. So we need, from our perspective, to look at this and reevaluate the whole essence of child labor. That's why the problem from our perspective, and that's why I got involved in this.
Thank you. And then Naomi, you've had some significant experience working on
Yeah,
child abuse and neglect issues.
yeah, I guess just to build a little bit off. So many microphones. Just to build a little bit off of Owen's point in terms of the context that children are finding themselves in. Better, yeah. The situations that a lot of children are finding themselves in here in the US. So as Owen mentioned, a lot of children who are experiencing child labor and exploitation here are unaccompanied minors. We're seeing political instability across the world, widening economic inequality, and now climate displacement too, bringing a lot of children or making them leave their families and their homes. And a lot of people are coming here to the US and are trying to support themselves in whatever way they can. But another group of youth that are really impacted by child labor and exploitation are system-involved youth. So the US is the country with the highest rate of incarceration, and so through that, it's affecting children in a number of different ways. So children are either growing up with a parent who's incarcerated, which creates a more unstable home life and also limits their ability for economic stability growing up, or children might be, I can't tell if it's working still, children might be incarcerated themselves, which disrupts their childhood and limits their ability for stable income throughout the rest of their life, and again is driving more situations of vulnerability. And then another focus is through the family regulation system. So if children are either removed from their homes and their sort of support network, so someone that they could reach out to, have a trusted adult to kind of look for support if they find themselves in situations of exploitation. They're losing that resource, and also that children who end up in the foster care system are much more likely to experience trafficking and exploitation. So that's just another group of youth that we're seeing affected by this in the US.
Thank you, thank you. Ben, did you want to make any follow-up comments, or are you? Good for now.
I'm fine for now, Brian. Yeah.
Okay, thank you. Well, why don't we turn to really a central theme then of our panel today, which is to what extent are any of the norms that we've mentioned in the ILO conventions, the CRC, the declarations, are these now part of customary international law? And does that matter? Why would it be relevant, given that we have these very widely ratified treaties, for example? So I'm actually going to first turn to Rosanna, who has done, as I said, she's published a book, a very plain book on the legal impact of General Assembly resolutions. So I think she'd like to address in particular the implications of the 1959 Declaration on the Rights of the Child for customary international law.
Yes, I hope you can hear me okay. Good.
I think we always have to, for those mics, we have to just lean in close apparently, so.
Oh, thank you very much, Brian, for the question. You asked me to play a little bit with legal theory in this panel today. I'm going to do that very, very briefly, and also we take a very pragmatic approach as in the book. And my comments come off the back of the very terrifying numbers that you have just heard from the other panelists. So we'll see whether I am too far off on point of theory about the legal significance. Focusing on the 1959 Declaration of the Rights of the Child, adopted by the General Assembly of the United Nations in 1959. So is it customary international law? The whole point of asking this question is that if the answer is yes, then it creates legally binding obligations for the international community as a whole, whether or not states have signed and ratified other treaties on the very same topic. So I think that there are at least two ways in which we can see this question and try to answer this question. So the first way is to try to determine whether the Declaration of 1959 was reflecting a customary international law at the time of adoption. In other words, whether it was customary international law already back in 1959. And the other, probably alternative approach is to determine whether the declaration has somehow facilitated the formation of customary international law, crystallization of rules of customary international law from the time of adoption, so from 1959 up to today. For these initial remarks, I'm just going to focus, for the sake of relative simplicity, on the first of two options, probably the most controversial bit of this story about customary international law, and so whether the Declaration of 1959 was reflecting customary international law back in 1959. And I think that the first thing to point out, even out of good sense if you want, is that if we look at the history, negotiating history of the declaration, it is pretty obvious that it builds on other documents. Some of them you have already mentioned in our review, Brian. And so they range from the 1924 Geneva Declaration all the way through the 1950 draft by the ECOSOC Temporary Social Commission, and then in 1959 the work of the Human Rights Commission first, and then obviously the General Assembly adopting the declaration that we have today. So the point that I'm making here is that there is a certain degree of continuity from one document to the other about the declaration as a whole, but also the specific provisions of the declaration. Principle 9 really addresses the topics that we are discussing in this panel. So the prohibition of child labor, exploitation, and also trafficking in children. But I am very hesitant to draw inferences about the customary status of the declaration just by engaging in this exercise of comparing texts. This is a very formalistic approach which does not really disclose anything about actual state practice and probably opinion juris. So that's why I am a little bit hesitant. And I will also go as far as to say that, in my view, the 1959 Declaration, as important as it is not an instance of the so-called instant customary international law. Although it's true that it was discussed and considered only in 1959 by the General Assembly, with the declaration adopted at the end of that regular session, but I think that it is not sufficient to say that it was customary international law back then. And I'll give you very, very briefly two reasons to explain my skepticism on this point as well. The first one is that if we stick for a second to this game of comparing texts and we look at Principle 9 of the 1959 Declaration adopted by the General Assembly, and we compare it to the equivalent provision, which is Principle 10 in the Human Rights Commission document, again adopted in 1959, we see that immediately we are talking about identical texts. Just two additions inserted by the General Assembly Third Committee and then approved in plenary session. And these insertions are drafting issues more than anything else. But anyway, in the first paragraph of Principle 9, at the request of the delegation of Romania, there was the mention to explicit mention of trafficking children added to the idea of exploitation. According to Romania in some states which endorsed the amendment at the end of the day, the two things needed to be separated. So trafficking in children has no stand on its own in the declaration, and for the same reason other delegations opposed this extension of the text of Principle 9, paragraph 1, because it would have made a redundant point, they said, also making the declaration very heavy to read, and the whole point of the declaration was to be useful for the lay person, not really for states, as it was a sort of educative document more than anything else. And the second addition we have in the second paragraph of Principle 9, and it's there just the introduction of a single word, minimum, by the declaration, by the delegation of Venezuela. The word minimum in between acceptable and age of the children, basically indicating that any child employed below an acceptable minimum age was something to be perceived as unlawful and therefore to be avoided. And the delegation of Venezuela, the reason why they introduced this amendment was to try to align somehow the text of the Declaration of 1959 to the ILO standards. I will recognize that back in 1959, quite a number of states had not yet ratified the relevant ILO documents, and so that was a way of forcing gently, as gently as possible, all the states endorsing the declaration to also align to those standards. But for the same reason, other states and the delegations opposed that amendment, saying that, well, once you insert what minimum in the declaration, then states have the freedom to impart the interpretation they want to that word, and therefore the risk was that it would be a departure of the alignments with the meaning given by the ILO in those conventions to the word minimum. And so there was pretty much, to go back to my point on instant customary international law continuity as opposed to divergence. And then the second point, it's just, again, a very empirical one. If we look at some of the comments, statements made by the delegation in the Third Committee of the General Assembly in 1959, there was a good number of states, honestly, mostly coming from the Soviet bloc, like the Soviet Union, Russia, but also Czechoslovakia, Romania, and so on and so forth. They basically being stated before the other delegates in the General Assembly that in 1959, as they were discussing the text of the declaration, the issue of child labor and exploitation, including human trafficking in particular, was quite common in several states in various areas of the world, and precisely because of that, they needed a declaration to eradicate the practice. So all in all, taken together, seen from this very narrow angle, I will reach the conclusion that the declaration in 1959 was not customary international law at the time of adoption. But I reach the opposite conclusion if I look at the other way around, the influence it has had since adoption in 1959 after the present. So, but it is a lost here.
Yeah, and of course, that's an important question because that 1959 declaration really laid the foundation for the CRC 30 years later, which has now become, the most widely ratified human rights treaty. Along with the ILO conventions, I think it's appropriate to ask whether we can now say that these norms are customary international law, at least the foundational norms of the children's right to be free of exploitation and cruelty and neglect, which was, by the way, first paragraph that Rosanna was referring to in Principle 9, but also the principle that children should not have to work before an appropriate minimum age, which is what the Principle 9 here refers to, and definitely be free of any kind of harmful work, any work that would interfere with education. And so looking at it today, I'm going to first turn to Doug actually for some insight into is this norm part of customary law, and then we can turn to Alan and see if you have some further thoughts.
Thank you, Brian, and for the invitation to the panel. Let me begin by the caveat that I express only my personal views and not those of any law firm, client, or association with which I might be affiliated.
Those lawyers, I tell you.
I gotta say that. What if somebody reads this? First of all, picking up on what Rosanna just said, it's quite common in the area of international human rights law for declarations to precede treaties. Declarations are often used as stepping stones to nudge the member states of the UN into finally recognizing that they have to get stuck with a treaty. That happened not only in the area of children's rights, but also women's rights, torture, and some other areas. Secondly, Alan's commented earlier that there are situations where the international norms against child labor are at least debatable in terms of their impact on child welfare. He gave Cambodia as an example. I've done quite a bit of work in El Salvador. I don't know what the statistics are today, but I remember, I think it was 10 years ago, I read that there were 70,000 children in that small country who had no school to go to. And should you tell those children and their parents that they cannot work, at least in reasonably safe conditions? So one perspective on the whole issue of child labor is child education. There's a basic fundamental human right globally to education. And until we make progress on that, I think we have to be very careful in how we implement norms concerning child labor. Now, in terms of customary international law, it's difficult for me to think of any area of international law, and certainly of international human rights law, Brian, with all due respect to your publications and to your committee, where there is less need for customary international law. You've heard from all the other speakers that we have these treaties ratified by 187 states. We have the declaration of the ILO, which is binding on all the ILO members about fundamental rights at work. And those treaties are not just treaties, they obligate the member states to pass domestic legislation to implement the treaties. And even in the United States, which hasn't joined either the Children's Rights Convention or the Minimum Age Convention, the United States, as we heard from Owen, has, and from Naomi, has extensive domestic legislation on the subject. So for me, the first question, although normally it would be the second, but for me, the first question is, who cares? What does it matter? I'm trying to imagine a situation where it would matter. I can think of a few far-fetched cases. First of all, there are a handful of countries in the world that haven't ratified all these ILO treaties. In theory, customary international law could matter with regard to those states, but I wonder how many of them are utterly lacking in any domestic legislation on the subject. I suspect, I haven't checked, that most of those handful of states that are not parties to the international treaties have some kind of laws or regulations on the subject anyway. But if they don't, if you find a country that has no law and no treaty participation on child labor, then by God, take your customary international law and run with it. Use it for all it's worth. But that's going to be a rare case. The other is in a country like the United States, which is not party, let's say, to the Minimum Wage Convention, and you're trying to enforce international labor law with respect to children in the domestic courts of that country. In the United States, you could try to do that, excuse me, under the Alien Statute. But that statute has been so named by the United States Supreme Court, which basically rules that it's useless for any activity taking place outside the United States. That it has no practical impact. And at least as of a decade ago, there was, as far as I know, no other country in the world that even had a domestic statute that allowed for the enforcement of customary international law before domestic courts. Now, that's changed a bit in recent years with the French loi de vigilance, and potentially in a few years down the road with the European Union's CSRD, the Corporate Sustainability Due Diligence Directive. But those will be implemented by national laws in European countries, all of which already have child labor laws. So it's an interesting theoretical question akin to the number of angels that can dance on a pinhead to explore customary international law here, but it's not much more than theoretical. But turning to the theoretical question, I see a basic norm, but a problem. The basic norm is that we have all these international obligations, which add up to obligo juris. We have all this international practice in terms of joining the treaties and adopting implementing laws to show widespread state practice. Those are the two elements of customary international law generally. But what about a third element, which is hardly ever addressed? I haven't read your book, Brian, so maybe you took it on. It's hardly ever addressed either in scholarship or in jurisprudence, and that is clarity, specificity. We heard from the gentleman from the ILO about the minimum age convention. Depending on what country you're in, what economy that country has, what industry we're talking about, what guidelines the ILO has issued, the minimum age for child labor is either 12, 13, 14, 15, 16, or 18. I'm not sure there's any with 17, but there's, fortunately for that, the optional protocol on recruitment of child soldiers comes into play because 17 is a key age there. So how can you have a customary norm that has any application in practice if we don't know what the age is without getting into those specificities? And to me, the answer is it depends on what you're trying to do with it. For example, if it's a reporting obligation, you could say anything under 18 is child labor, and we want companies to report on that. That's what the new Canadian law, as I understand it, says. But if we're talking about either criminal prosecution or civil liability, then you have issues of due process and of the principle of legality. Are we going to prosecute a company for engaging in or being associated with in its supply chain child labor when we don't know which age applies, depending on which country, which economy, and which industry, and which guideline? Same thing for civil liability. So I think you can make a case, Brian, that there's customary international law, but you have to go on and ask the question, for what purpose? And in some cases, even if the norm exists, it should not be used.
Okay, thank you. Well, you can see we don't shy away from inviting a wide variety of opinions here. I will just suggest, though, that customary international law can be quite relevant even when we have widely ratified treaties. And I think, Alan, you might actually address this, in particular when it comes to the domestic role of customary international law in different legal systems. It may actually be more effective in domestic law than treaties, depending on the legal status of those treaties. But also, the International Court of Justice has recognized in cases like Nicaragua that customary norms can coexist alongside treaty norms. I think this is quite relevant, actually, though, to the United States. We just went through a panel before this one on the relevance of the CRC for the US, which, of course, is not a party, but there was a presentation by a representative of Human Rights Watch, which has undertaken an extensive study and shows just how far short of international standards, including the ILO conventions, US states and even the federal standards actually fall. And in particular, with very broad exemptions for agricultural, child labor, which don't accord actually with these, even the ILO standards, let alone customary international law. But customary international law would of course bind the United States, even as a non-party. And so you could say, well, why does that matter? Either, except we do believe that, the Supreme Court has said customary international law is in fact part of U.S. law. Yes, in an unspecified way, and what is the exact rule, but nevertheless. Okay, I just exercised my privilege as moderator to make that point. Let me turn to Alan because, and again, I do want to keep an eye on the time. So if we can try to be fairly brief, and then we'll get to our final question about what can we do in terms of actually implementing these standards, whether in treaties or customary law to help children. So go ahead, Alan.
So what I wanted to raise was this, Canada is, I'm Canadian. Canada is a signatory to the Convention on the Rights of the Child. The issue came up before the Supreme Court of Canada a few years ago. Did a child in Canada have the rights under the CRC that were enforceable in Canada? And our Supreme Court said, no, you don't have it. Why? While Canada ratified, they didn't pass implementing legislation. And in especially common law countries, there needs to be implementation by legislation. Otherwise, the treaty binds Canada vis-a-vis the other signatories, but it doesn't provide any rights to people in Canada. And that's when I looked at this and sort of the reason the panel is largely about customary international laws. If that was argued, which it wasn't at the time, that Canada was bound because the CRC and the rights of the child are customary international law, the court would have likely had to come down with the opposite answer, which is the child has rights under the CRC because that is now customary international law. So for me, that was a threshold issue. If it's customary international law, people have rights under it, whereas if it's not, if it's only a treaty, the people don't have any rights, right? There's no human right based on a treaty unless it's already implemented into Canadian law. So that's why, to me, this is such a major issue.
Thank you, Alan.
Right, a rebuttal on the
what-
two of you?
A rebuttal? Yes, go
Very
ahead.
quickly. US law, you stated that customary international law is part of US law, but you didn't finish the sentence from the Paquete Havana case of 2000. Unless there is controlling legislation, executive regulation, or jurisprudence. And so a US court attempting to say there's customary international law based on the ILO convention age limits would have to confront all of that domestic US legislation and say customary international law overrides all that. The current Supreme Court would not do that. In Canada, customary international law is part of the common law, but not in an enforceable way unless the Supreme Court of Canada says so. And in the Anaya case from Anaya, I forget the last name of it, but it's the Eritrea case where a Canadian company was complicit in forced labor in Eritrea by a 5-4 vote, and this was after the case you mentioned. The Canadian Supreme Court managed to say, at least in the case of forced labor, that somehow the lower courts had to work that in. But I'm not at all sure they would do the same for child labor. So I think you're raising good issues to litigate. I'm not sure either of you would win.
Okay, well, let me turn to Ben now and our final question, which is really what can we do to better implement existing standards, whether they're in treaties or even domestic legislation for that matter, or in customary international law. So let me turn to Ben, and of course you're welcome to react to anything else you may have heard just now, Ben. What do you think can be done? And I know that, of course, the ILO is very active in trying to address many of these issues, including one that came up in our discussion, which is the challenge of actually ensuring that children have access to education.
Yeah, thank you. I mean, just to react a bit to the conversation, in terms of the rights that are embedded in the ILO conventions, you know, they're human rights, so they're inalienable and they're universal. So you know, we have to be careful not to sort of create a double standard amongst, you know, children in rich countries versus children in developing countries, just because those children don't have access to proper schooling, et cetera. So, I mean, they have the same right to be free from child labor in Cambodia as a child in Canada or anywhere else. So I think the point about the maintaining that protection is critically important in domestic law, as you say. So transposing the conventions into a minimum age. How you apply and how you enforce that is makes a huge difference. And our approach is to say, look, you can't just ban child labor. That could end up, you know, putting children into even worse off situations. You've got to address the root cause and provide alternatives to child labor. So things like education and, you know, enrollment rates in Cambodia as the panelist said are low, not where they should be, about 90%. So you need to expand the coverage of education, but also quality. Too often, education and schooling is seen as something that is just not relevant or something that's going to lead to a good job at the end of the day. So parents say, why should I send my child? Why should I make the sacrifice and send the child to school? So working on education quality is critical. Social protection I mentioned. So you know, think of the case of orphans and vulnerable children, child-headed households. It's the government's responsibility to sort that out. We can't place the onus on children themselves to work themselves out of poverty or fend for themselves. And so social protection has been one of the factors that's really paid good dividends. And in Latin America, child labor rates have dropped steeply, in large part thanks to things like cash transfers to families below that are in household poverty. So just to mention a couple of those things, I think decent work for parents, and I would say, you know, to the argument that a child working in Cambodia has won the lottery by having a job in a factory. I think that, you know, offering that same job to her mother so that she could send the child to school would be better in terms of labor market development and a decent work approach to eliminating child labor. So just to touch on a few elements of the ILO's approach, Brian, it's really about good legal systems, and then enforcement being kind of secondary to labor inspectors, for example, need to assist families and refer children to services rather than take a very kind of sanctions first approach, because again, that could just lead to worsening the problem that's driving the issue in the first place, household poverty. So it's very much a development issue. Of course, when it comes to worse forms, there's no room for compromise on those, and there it is indeed a question of sanctioning and penalizing offenders that are you know, involving children in commercial sexual exploitation and slavery, debt bondage, that sort of thing. But overall, it very much is goes hand in hand with education and social protection and community development.
Thank you.
May I say something real quick?
Yes, absolutely. I was going to just invite you to comment.
I think we have to be very careful when we start talking about root causes of child labor being lack of access to education, healthcare, and parents having decent jobs. The fact is, when we talk about child labor, it is profitable, and companies profit from utilizing child labor. It's cheaper. And until we come to grips with this reality, I think we are going to have this issue going on and be perpetuated. Alan and I, we've talked about this. And oftentimes you find that individuals involved in child labor is contributing to their family's well-being, right? But then when we look at the supply chain, we find that the companies that produce these products that these young people are producing are the ones who are the big beneficiaries from this relationship. So I think we must be careful it's important to look at decent access to education for their parents, right? But we also have to look at the bottom line, and that companies are in business to make money, period.
Naomi, you want to share any thoughts on this?
Yeah, I realize we are going into our question time, so I'll keep it very brief, but I would echo a lot of what Ben was saying both now and earlier in terms of while we are centering children's experiences and leveraging the treaties that are protecting their rights, I think that it has to be a larger evaluation. So both through the technical assistance program that the ILO addresses and other treaties that are looking at the issues of deep poverty as a whole, I think that we can still center children while evaluating the circumstances that families and communities are facing as a whole. And then just from a practical standpoint, now that children are in this situation, what other alternatives do they have? So realizing that they need to have some other source of community support. Oftentimes, if we're talking about the US here, a lot of these children don't have trusted adults that they can reach out to if they're finding themselves in situations of exploitation. And if they may have made a report before and not had that investigation, and feel isolated if they've made a report to someone and for the conditions of their workplace and no one is coming to their aid. And then also they might fear, carceral or punitive responses from certain state agencies if they're reaching out to them for support. So realizing that we have to provide, on a more individual level, alternatives for children who are experiencing this beyond just the larger system.
Okay, thank you. Well, we did get a bit of a late start, but we definitely want to leave time for conversation with all of you. So unless our panelists have any burning points to make, I'd like to open it up for any questions. So yeah, go ahead.
Hello, my name is Manita Harrison Travis. I'm an LLM student at the Fletcher School for Law and Diplomacy. I had a question. This is really loud.
Unlike our speakers up here.
Yeah.
Right?
I'm already a pretty loud speaker. I wanted just if you could talk a little bit about any corporate obligations to the CRC. I think that right now in the collective mind, everybody's thinking about the cobalt mines in the Congo or in the DRC, and these mining companies are owned by Canadian companies or also Chinese companies. So are there any extraterritorial obligations of these nations to hold these countries to standards, even though they're operating in other territories besides their own?
Thanks. You like to? Yeah.
Soft law, yes, hard law developing. Soft law, the UN guiding principles on business and human rights encourage but do not mandate states to obligate their companies to respect human rights outside the territorial borders of the states. The companies themselves are enjoined, I'll use that word, by the portion of the UN guiding principles that directs itself to companies rather than states to respect human rights, including those in the ILO Declaration of Fundamental Rights at Work, which include no child labor, and also indicates to abide by all national laws, if there are any that are applicable to the Congo or another such country. And there are all kinds of reports by UN human rights treaty committees and rapporteurs that suggest that companies have these obligations, but that's all soft law. In the area of hard law, we're going to be seeing that we see it already in the French law division loss that was only passed in 2017. In the German law, which came into effect 2023, the supply chain law, and the Norwegian Transparency Act that also came into effect in 2023. And those laws, with some exceptions, apply not only to their national companies, but to foreign companies that do business in those countries. The big gorilla on the horizon is the European Union Corporate Sustainability Due Diligence Directive, which, when it kicks in 3 years, will require large companies, but only large companies. I mean, these are really large companies covered by it, to respect international human rights extraterritorially, and if they don't, they're subject to fines and to civil liability, and in some countries to criminal prosecution. So we're moving in a direction of requiring that by hard law. But what I do, I spend my days advising big companies on their human rights commitments. And I point out to them, as do my colleagues at other law firms who advise other big companies, that you shouldn't wait for the hard law to bang you on the head. You have to worry already about reputational capital, media exposés, Human Rights Watch exposés, banks that are increasingly under pressure to pay attention to these things, your own access to capital, your cost of capital. So it's in your business interest to pay attention to these international norms as they're developing, and don't wait until somebody sues you or somebody prosecutes you.
We had another question? Yeah, back.
Thank you. My name is Rodrigo. I'm a student here at Fordham University, and I'm from Mexico, a country that has ratified both the Declaration and the Convent of '59 and the declarations thereafter. Nonetheless, it is a country where, sadly, big part of the territory is often controlled by organized crime and organized groups, including the cartel. And within these groups, they tend to evade both local, state, and federal legislation and justice, as well as international law. And they exist in this kind of legal voids in the country for a number of reasons. The biggest one of them being government compliance to these organized crime. And these groups tend to recruit a lot of children and they exploit them in different ways, one of them being forced labor. What is the course of action that the international community can take or international law can take to address these kind of legal voids? Or should we just accept the practical limitations of international law and leave this kind of situations to domestic law enforcement?
States have a duty, a positive duty, to protect the human rights of their citizens. So certainly cases could be brought before the Inter-American Court, ordering Mexico to do what it can to deal with these situations. Now, having said that, that's a kind of a legalistic answer. The practical answer is you and what army is going to go up against the Chapo and those drug gangs. I don't personally know what would be the answer if we assumed a Mexican government acting honestly in good faith attempted to do everything it could to take back control of those areas of Mexico. I don't know what would happen, but at least they have the obligation to try, and an international court could order them to undertake that obligation if they haven't done it voluntarily.
Yeah, Ben, do you have any comments on that?
Well, I think, the use of children in illicit activities, in armed conflict is a violation of Convention 182. So the government is, responsible, and the ILO's supervisory mechanism is one avenue for other states, but also Mexican workers and employers organizations to raise the case and bring pressure on the Mexican government to do that, because it's a worse form of child labor. in terms of an army, we don't have one, obviously, the ILO, UN. So it's more of the moral persuasion and pressure, and the fact that governments don't like to be dragged in front of tribunals and so on. But yeah, it's clearly a violation of the commitments made by Mexico under 182.
Okay. Any other questions? Okay, yes.
Oh, there's one back
Back there.
Sorry, I split my time between this panel and the climate refugees panel, so I apologize if I talk about something that wasn't discussed or that you've already discussed. But considering both panels, I'm thinking about child labor and DRC, particularly within the cobalt mines and the overlap of extractive industries, conflict, and climate justice. And wanted to hear about if you had any thoughts in that area in particular.
Okay. Well, I think we did hear a similar question, but you're particularly
so
concerned
sorry.
about, that's okay. You just came in?
I was here at the first half and then I went to the climate review.
Okay. Okay, gotcha. Okay, I think we did answer a similar question about the cobalt mines in DRC, so, but thank you. Thanks for sharing that. Any other thoughts? Okay, Doug's got
I
it.
think there's a similarity in that with Rodrigo's question, which I don't know if you heard about Mexico. And that is, whether we're talking about international law or domestic law, the law can only go so far. If you have a government which does not control territory, if you have territory which is controlled by lawless, armed gangs that are powerful, the law is more theoretical than real. And that's true in some areas of the Congo. It's true in some areas of Mexico. It's true in many places around the world. So one of the jobs for any of these panels here at the conference is to try to expand the effectiveness of governments, of courts, of the rule of law in more and more territories. Because if you don't have that, all of these domestic and international laws simply are on paper, but not on the real world.
Very good point. Yes, I think that's Allison.
Oh, I'm Allison Denny-Gentile. I'm from the University of Southern California, and when I finished college, I spent a year in the School of Economics. I worked at Anti-Slavery Society for the Protection of Human Rights, and at that time they were now Anti-Slavery International, and they worked on child labor. So my first introduction to human rights was through this topic, and thank you for your very fascinating insights and suggestions for positive change. I'm wondering what organizations or NGOs you think have been most effective as advocates. You've mentioned Human Rights Watch, Children's Rights. What kinds of NGOs, or if students and lawyers want to contribute to the movement to promote children's rights, in your experience, which ones do you think have been effective, are culturally sensitive, and deserve our support?
One rule of thumb I've always used with my students in many years of teaching and practicing is that whatever international or global NGO is trying to work on an issue should partner with credible local organizations who can speak for the people and the community and the victims. And so the answer would depend very much on what country you're talking about. In terms of global organizations, I defer to others on this panel because I'm a sort of human rights generalist, not a specialist on children's rights NGOs.
Did you have any thoughts, Naomi?
I will just put a plug for the Kemp Center. I think that they do partner with a lot of different organizations and elevate the voices of children who are exploited. So, but I mean, I would agree that it's going to be at a local level and an international. I think that what I was saying earlier in terms of finding local communities that are working one-on-one with children who are impacted. So maybe not necessarily in the limelight, so like Rainier Beach Action Coalition, it's an organization in South Seattle that's doing a lot of important work with youth, but that's not necessarily going to be relevant for your work here, wherever you're located.
Sorry, can you say that organization one more time, the
Rainier Beach Action Coalition, but it's a small local organization in South Seattle, so I think it's just important to look at each different level, but I would definitely say that the Camp Center is doing a lot of this work.
Thank you. Other questions? I think it's probably, oh, wonderful. Yeah.
I'm sorry because my English is awful. I'm from French branch of International Law Association, and I just wanted to add something about French procedures for those who are interested in the DRC. There is a new beginning procedures from Congo against Apple. We have precedents, non-binding, but precedents against huge companies for violation of human rights. I don't know if the current procedures deals with children labor, but it deals about human rights, and the judges already have in France sanctioned companies arguing about their ethic charters. And it is not just soft law, soft international law, it's their own laws that are considered as quasi-contracts. So it's beginning to be a hard law. And the procedures against Apple will probably be very interesting, but it's just the beginning.
Okay. Well, thank you so much. Thank you, everybody, and please join me in thanking our panelists. Including Ben, who's much later in Geneva, so we really appreciate you joining us, Ben. Thank you.
It's a great range of views.
That's right. Well, we could have a conversation.
We could,
Yeah, we could. One always has to draw a distinction between, there's a question about international law, of course, treated in US laws. But you're right, the doctrine has come down since Paquette on it. Of course, it really, really does.
Where it comes in handy is you have a reasonable Congress or state legislature. You can use customary international law to justify national legislation.
Yeah, exactly. I mean, where it does exist at the international level, it can be used in persuasion, right? And
yeah,
we're trying to persuade states, for example, to adopt more.
And that adds legitimacy to the persuasion.
Yeah, exactly, exactly. Wonderful.
We don't want to read it.
What's that?
What did they talk about in the last panel? Was states are lowering the protection of children, right?
They are.
Yeah. Many states, like my own, Nebraska.
I'll get to that.
Oh, you mean US states?
Yes,
Oh,
yeah, sorry, US.
Yeah.
That's